Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is GB Satusa, and I'll be your host for today's discussion, From Green Card to Citizenship, Understanding the 3-Year Rule, 5-Year Rule, and Special Eligibility Categories. Becoming a U.S. citizen is one of the most meaningful steps in the immigration journey, but eligibility can be confusing. Some qualify after 3 years as the spouse of a U.S. citizen, others must wait 5 years as permanent residents. And for many, military service, VAWA protection, or refugee status may place them in a separate category. Understanding how these rules apply, how USCIS evaluates applications, and what evidence strengthens an N400 is essential for anyone preparing to naturalize. To help us break this down, we are joined by attorney Gunda Brost, Esquire, an experienced immigration attorney and the founding attorney of Brost Law Office in Cedar Falls, Iowa. With over 15 years of experience, she focuses on waivers, asylum, naturalization, and complex immigration matters before USCIS and at the consular level. Fluent in English, Spanish, German, and French, she brings a multilingual and informed perspective to the complexities of the naturalization process. You're welcome, Attorney Brost. We're glad to have you join us today.
Yes, thank you so much. Yes. So my name is Gunda Brost, and I'm an immigration attorney in Cedar Falls, Iowa. And I will be talking about the special rules regarding naturalization today. Can we go ahead and share the PowerPoint?
Before we begin, Attorney, a
Yes.
quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals and families can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get insightful. Grab your writing pads and pens and share the link with your friends. If you have not subscribed, now is the right time to do so. Just click on the subscribe button and you're all set now. Now, let's dive into today's discussion. Attorney, could you explain the key differences between the 3-year and 5-year naturalization eligibility rules and how USCIS determines which one applies to a green card holder?
Yes, so the general provision is the 5-year rule, right? That applies to most people. In general, an applicant for naturalization must have held permanent residence status for 5 years in order to be eligible to file for citizenship. Asylees may count the 1 year that they spent in asylee status towards these 5 years, which is a special rule. Refugees may count all the years that they've spent in refugee status while in the U.S. towards this 5-year period. And then an applicant is also able to file up to 90 days early. So that means they can file under the general provision 4 years and 9 months, as long as they have been in that status as a lawful permanent resident in that status for that time.
All right. Now, many applicants struggle with continuous residence and physical presence requirements. What common mistakes should they avoid when calculating these timelines?
So the concept of continuous residency is that the applicant for citizenship must maintain a permanent dwelling place in the United States over the period of time required by the statute, which is 3 or 4, 5 years. It's called a statutory period, and an applicant for naturalization under the general provision must have resided continuously in the United States after his or her lawful permanent resident status admission for at least 5 years prior to filing the naturalization application and up to the time of naturalization. An applicant must also establish that he or she has resided in the state or service district for at least 3 months prior to filing. So that's continuous residency. We have ways that it can be disrupted. So, for instance, if the applicant is absent from the United States for more than 6 months, or even more than a year at a time, right? That will disrupt the continuous residency. So if absent for more than 6 months but less than 1 year, there's a rebuttable presumption that the continuous residency has been broken, but this can be rebutted by showing USCIS continued ties to the United States, such as the applicant having not terminated employment in the US or having close relatives that maintained residence in the US, and other ways. However, an absence of more than 1 year abroad will automatically break continuous residence unless the applicant is then an approved application to preserve the residency for naturalization purposes, which is the Form N-470. Okay, so I don't know in how much detail you wanted to go with that, but once the continuous residency has been broken, the applicant will need to wait at least 4 years and 1 day after having returned to the US to be able to show the required period of continuous residency for naturalization. And then, even then, the period of absence must have occurred, must have been less than a year. Since the period of absence is still over 6 months, though, then an applicant for naturalization in these circumstances must also overcome the presumption of a break in the continuity of residence. So it might be best to wait 4 years and 6 months, then you don't have to deal with that issue.
All right. So, how do special eligibility categories, including military service, marriage to a US citizen, or refugee status, influence the naturalization timeline and overall application process?
Great question. So the people, so if you are became a green card holder based on the marriage to a U.S. citizen, then there is a special 3-year rule that applies. If you're still married to the same U.S. citizen who petitioned for you, you are eligible to file for naturalization within 3 years instead of 5. And actually, that since you can also file 90 days early, it's more like 2 years and 9 months from the date that you have received lawful permanent resident status. Of course, the applicant must meet all other eligibility requirements for naturalization, which are the age, good moral character, physical presence, continuous residency, state residency, English proficiency, civics knowledge, willingness to take the oath of allegiance, etc. And they must still be living in marital union with the same U.S. citizen spouse who petitioned for their green card, the initial green card.
Right. Now,
we also have the special 1-year rule for the military personnel. So military personnel would be Army, Navy, Marine Corps, Air Force, Coast Guard, National Guard, active members, or veterans. Both apply. And an alien, so this is the language, an alien who has served honorably in the U.S. Armed Forces and was separated under honorable conditions, may be eligible for naturalization under INA 328 if he or she served 1 year or more at any time, or under INA 329 if he or she served for any length of time during a specifically designated period. And in order to request certification of their military service, they would need to get that Form N-426. And the good thing is that there is no presence requirement if you're going to go by the special 1-year rule for military personnel. And you can also request expedited processing, which means generally that the citizenship application can go much faster for the entire process.
all right. Now, background checks, tax issues, and criminal history often create complications. What are the most frequent factors that lead USCIS to delay or deny naturalization? And how can applicants prepare in advance to reduce these risks?
So obviously, I'm an immigration lawyer, so I may be biased when I say it might be a good idea to have, legal counsel help you prepare your application, and then also prepare you for the naturalization interview and attend the naturalization interview if you're able to do all of those. But the solid application and good screening would be immensely important. So you want to make sure that there is no disqualifying criminal history. The good moral character time period is 5 years, looking back 5 years from the time of application. But of course, USCIS can go beyond this time period in its discretion. So before you apply to naturalization, you should check that there's no serious criminal convictions that might actually, make you ineligible for naturalization and could even lead to removal proceedings and your green card being taken away. So it's very important to be screened for criminal background. Also, these must be disclosed at all times. So you can't, try to say to the question, have you ever been arrested? No, when you in fact have been, because then you also fail to meet, then you're kind of lying under oath, right? So you would also fail to meet the good moral character requirement. As for your tax history, not filing taxes properly or owing taxes can also be shown to be seen to show the lack of good moral character. So make sure that the applicant has a payment plan with the IRS for outstanding obligations and is making the payments properly. You need to make sure that you've never made a false claim to U.S. citizenship, because we know this in immigration law as like the death knell of immigration law, because there's no waiver that exists, and then such a claim can make you forever ineligible for any immigration benefit. So where would you look for potential false claims of U.S. citizenship? Well, has the applicant ever registered to vote or actually voted? Or have they marked U.S. citizen on any employment form? Because those could also be seen as a false claim. Male applicants should make sure that whether or not they meet the requirement that they have registered. So all males between the ages of 18 and 25 in the United States need to have registered during those ages for select services. And then screen for your travel history so that you check that there are no issues with continuous residency and physical presence, which I mentioned earlier. And then, of course, you need to also be willing to take the oath of allegiance. I have had some clients who don't want to do that because it involves, you are basically in one of them, you're saying, I'm taking an oath to bear arms on behalf of the United States. And that, if your client or you are a pacifist or something, you may have an issue. So then you may require a waiver for that based on very strong religious or moral beliefs. And of course, you need to screen for English speaking ability. There are some exemptions. So there's what's called the 50-20 or the 55-15 rule, meaning if the applicant is at least 50 years old and has had a green card for 20 years, or they are 55 or older and have had it for at least 15 rules, they can get some special considerations. So they don't need to do the English test. Also, if they have a disability, they may be able to file for a medical disability request if it impedes them from learning English fluently or doing the civics test. And then lastly, you need to provide the civic knowledge. So if you're not able to learn the civic knowledge based on a disability, you may want to also take that into consideration. Everybody else needs to pass that, whether in their language or in English. And there are some resources such as online. There's a lot of things you can do. Like all the questions are online. You can buy flashcards. You can go to community classes. You can form study groups. And some people study them with their family or their partner. So that is very important that you really take that seriously.
Now, for green card holders who travel frequently or have long absences abroad, what steps can they take to maintain eligibility under either the 3-year or 5-year rules?
Okay, so like I was saying earlier, with the physical presence and the continuous residency, you may want to make sure that you never abroad more than 6 months, to stay abroad less than 6 months. maintain your ties to the United States, such as not giving up your employment and maintaining your property here, maybe engaging in voting here, even if it's with absentee ballots. And then the other thing is the physical presence, which I hadn't really talked about yet, but it's a separate requirement. And it just means that for the general 5-year rule, you must have spent at least 30 months, which is like half of the 5 years, in the US physically present. And that's a cumulative total of the days that they will count, right? So one day, if you're one day above that, you will need to wait. And for the 3-year rule, which is based on the marriage to a U.S. citizen, then you might have to have had at least 18 months out of these 3 years immediately preceding the application spent physically in the U.S. So make sure that you know these requirements and that you are very careful with the time that you spend abroad so that you don't, break those requirements.
So, what practical advice would you offer to help applicants strengthen their naturalization applications, prepare for the civics and English tests, and avoid preventable delays or even denials?
So make sure that you have all the required documents that you will need to apply, such as your personal identification and a proof of your residency in the state, which usually that could be like a state driver's license or other state issued photo ID. You need to have your permanent resident. Sorry about that. You need to have your permanent resident card copy front and back, which is the form I-551. Your birth certificate, even a language other than English, it requires a certified English translation. You need to provide your passport and selective service registration. For any arrests or criminal issues, you need to have the police and court records with the final dispositions and the citations. And then the application forms and fees, they change all the time, right? You need to also now you cannot no longer provide a check or money order. You need to provide the electronic form, which is a G1450, and fill that out correctly. Travel documents. So you need to show, with your travel that you have not broken the physical presence or continuous residency requirements. So you need to kind of count the days that you were absent abroad, if at all, and you need to put that history on your N400 form. And then if your application is based on marriage to a U.S. citizen, obviously you'll need the marriage certificate and the divorce decree of any prior divorces you may have had, and then proof of continued marital union. And then if it's based on military provision, you'll need the military service documents, obviously, that show your eligibility for that. And then the pitfalls I was talking about, of course, make sure that you disclose any criminal history, have it screened if you think it might, or, I would say if you have any criminal history, have an immigration attorney screen it so that you're sure that this cannot affect your eligibility or lead to even worse consequences when you apply for naturalization. Screen for your tax history, make sure that you don't have any outstanding tax obligations, and if so, that you are paying them on a payment plan with the IRS. Make sure you never had a false claim of U.S. citizenship. Make sure if you're male that has lived in the U.S. between the ages of 18 and 25 that you did register for select services. Make sure that your travel history is not an issue, and then make sure you're willing to take the full oath of allegiance and know what it is. And of course, make sure that your English and civics are up to date.
All right. Now, to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for tuning in. Whether you plan to apply soon or are preparing for citizenship in the future, today's session is designed to give you clarity, structure, and confidence. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where immigrants, families, and professionals can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We are also proud to share that immigrationquestion.com is a triple B accredited business, reflecting our commitment to transparency, accountability, and service to immigrant communities. Attorney Brost, with your extensive experience in waivers, asylum, naturalization, and complex immigration matters, what are your thoughts on how a platform like immigrationquestion.com helps immigrants stay informed and prepare more effectively for this critical step?
For waivers, I believe these are immigration is a very, very complex area, right? And it's not getting any easier right now with like since the new administration, it's almost like it's definitely on a weekly basis, almost on a daily basis, that the law is somehow changing in the vast area of immigration practice, which may be more than just your naturalization application. But it's constantly changing, it's constantly evolving. For example, I was giving the example that you used to be able to pay with a check or money order for the USCIS filing fees, and you no longer are able to do that. If you do that, they will reject the application, send it back, because now they require you to use the electronic form G1450. That's a very new rule. So make sure that your forms that you file are up to date, because they are constantly being changed. And if the form is an outdated version, they will also reject your case. So I would say if you're not able to afford an immigration attorney, which is, in my opinion, best practice, you yourself need to be informed of all these constant changes. And in the event of waivers, those are highly complex also. I do certainly have clients who are very knowledgeable and very professional and can file these themselves with their research, but it is very labor intensive. And do consider, having an immigration attorney prepare and review your work.
Thank you for that perspective, Attorney Brost. Now, before we move into our live Q&A, let's tackle this final question. What practical strategies would you recommend for applicants to organize their documents, track their cases, and ensure their N400 stays on course while preparing for naturalization?
Okay, so you should have a cover letter of some sort, and then have that G1450 with a filing fee pretty much right after the cover letter. The cover letter should explain, hey, not hey, but dear immigration officer, I am this is my basis. Like I've been married to a U.S. citizen spouse for 3 years, or I've held a green card for 5 years, whatever the basis is. And then explain that you are hereby applying for naturalization. And then I would list the documents in the order that I put them in the packet. Make sure that the N400 is filled out properly, because nowadays they reject for missing a box and that kind of thing. Make sure that the documents are legible, make sure that it's the correct fee, that it's the correct address, filing address, that it's the correct version of the N400 that you're filing, uh, and that you are including all the evidence that is required, for the eligibility category with which you're filing. Then once you file that with the agency, expect a receipt notice. You can also file online now, the N400, which if you have a USCIS account, it's a very nice way to do it fast and kind of like oversee the process. You will get a receipt notice immediately upon submitting your petition. And with that receipt notice, you can kind of follow the case along, whether you get it online or whether you get the receipt notice as a paper notice. Keep that, and you can follow your case on my USCIS website with the receipt notice. And then next step would be biometrics, fingerprinting, criminal background check. So for that, you'll need to go to your USCIS, which has jurisdiction over where you live, and submit your fingerprints. Then they will do the background checks, and then you would be going for the interview for the N400, at which time they will assess your eligibility, your English and civics knowledge, and yeah. see if there's anything that may disqualify you. Hopefully not. So they very rarely give you the results, at the hearing. Sometimes they will say, yes, we will recommend this for approval. Sometimes I've even seen them like schedule people for an oath ceremony on the same day. But, it really changes by where you are and also by the administration. And so I would not expect that. I always tell my clients, expect the worst and hope for the best. So it may be a while before you hear back and get your oath ceremony scheduled. If it's denied, there are ways to appeal. Well, with an N36, you can hire an attorney for that, if you don't agree with that, or you can refile and just see what is the better option there.
If you've just joined us, we've been in an insightful discussion with attorney Gunda Brost on From Green Card to Citizenship, understanding the 3-year rule, 5-year rule, and special eligibility categories. We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many as possible during this session. All right. How will I know the one that applies to me between the 3-year rule and the 5-year rule?
Okay, so are you married to a U.S. citizen? Did this person petition for your green card? If this is how, if your U.S. citizen spouse is the one that you got your green card through, then you would be subject to the 3-year rule if you're still in marital union with them.
All right. How will I know the one that applies to me between the 3-year rule and the 5-year rule?
Okay, I feel like I kind of already answered that. So if you are not married to a U.S. citizen, I would assume that the 5-year rule, would apply to you unless you're in the military. So the 3-year rule is if you are married to a U.S. citizen and this is the person through whom you got your green card and you're still married to them happily.
All right.
So,
All right. I live with my spouse in the US, but they work overseas for 1 year. Can I still use the 3-year residence rule?
That would depend also on the reason why you live there. So I would get that approval of the form N470 that I was talking about earlier, so that you don't risk the green card, being in jeopardy. But you do have to fulfill those physical presence and continuous residency requirements. So, but there are some exceptions for reasons why you're there, like for the military or for certain nonprofits, or so I would analyze that perhaps with an immigration attorney, whether you still can meet that requirement.
All right. Let's get a lot question here. If I go out of country for more than 1 year but have re-entry permit, do I lose continuous residence?
Let's see, the re-entry permit would not necessarily affect that, but you, in any case, you need to maintain it with that. That's the purpose of that.
All right. My green card got lost. Does that delay my N400 or break any rule?
Okay, did you submit a copy of it when you filed the N400? Typically, having a paper copy is sufficient. But if not, or if there's any issue, you may want to, well, I always advise my clients file an I-190 so that you at least have the receipt, the renewal of, or like a lost green card petition, basically. and then you file the N400. But if you've already filed the N400 and provided a copy, you should be okay.
All right. What are the special rules for military veterans to become citizens faster?
Okay, so that was in one of my slides where you basically have to have 1 year that you served in the military, and then you should be able to apply for citizenship based on that. So it's very fast, and even the process can be expedited, the process itself for naturalizing.
All right. We have time for one more. Since they changed the civics test in 2025, will that make my interview harder?
Right. Well, that civics test was made more difficult, unfortunately. So, so the answer, unfortunately, is probably yes. I think right now it is overall, like the overall thing we're seeing is to make everything a little more complex, and it may make it more difficult, unfortunately, for people to immigrate and to receive permanent status here.
All right. Now, Attorney Brost, let's digress a little as we wrap up. There has been recent news that DHS has released a sweeping proposal that could change biometrics for nearly every immigration filer. How would you advise immigrants to stay informed and understand the potential impact of this directive on their immigration journeys?
Yes, so they are proposing having more people, including children, do biometric background checks. In the alleged purpose is to vet people for violations and to make everything more safe and streamlined. So as of right now, because it's just a proposed rule, we don't know the effects yet. I would suggest, or I would assume, this would make everything slow down a little more, because obviously we already have a huge backlog in most of all of our immigration petitions and our courts, and this is not going to make anything faster if everybody has to get their biometrics taken over and over again, and everybody is in that pool. So.
Thank you so much, Attorney Brost, for your time, insight, and clarity today. Your discussion has helped many viewers understand how naturalization eligibility works and how to prepare a strong and well-organized citizenship application. And to all our viewers, thank you for joining this conversation. We hope today's webinar helps you stay informed, organized, and confident as you move toward US citizenship. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's webinar or share it with others, the full replay will be available on Spotify soon. Just search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another live session exploring key immigration topics, including asylum updates, family petitions, employment visas, and compliance strategies. Once again, thank you, Attorney Gunda Brost, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected.
Thank you for having me. Bye.
Bye.